Welcome to Rebel Chaser. My name is Gail, and I've got 4 videos for you tonight. The first one is with Judge Colin Hunter, a false accusation video. The second one is with Referee Winther. I'll let you guys watch that. And the third one is with Judge Mogan. And I thought this one was interesting because of the reasons he did what he did. So I'll let you watch that. And then the fourth one is just a short one with Judge Washington. So I'll let you guys watch. I'll see you at the end.
Ma'am, you are Laura Ann Kenny, correct?
Yes, Your Honor.
All right, welcome back, Ms. Kenny. So as you know, and as the attorneys know, there was a proposed no contest plea based upon lack of memory last month. Based upon the information I had at the time, I did not find there was a basis to accept that plea. However, I recognize that the attorneys also were aware of more information. And I think on the record, even Ms. Koch, you offered that there was a supplementary police report which might have offered proof of guilt. I now have an updated police report which contained what was called a supplemental report that I reviewed. Mr. Gurmurthy, you must have provided that additionally after the last hearing.
I don't know if I did on this court's office did, but it was provided. I thought it was initially provided, but my apologies, but we have all the necessary documents for the court.
So is the intention of the defendant to still go forward with the plea?
That's my understanding, that she would still plead no contest to the attempt false report of a felony.
Is that the prosecutor's plea agreement?
Yes.
Ms. Kenny, do you understand the nature of the plea agreement and its terms?
Yes, Your Honor.
Did you want to go forward with the plea agreement under those terms?
Yes, Your Honor.
If you could raise your right hand. You solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
So Ms. Kenny, Ms. Harris is here today, and I recognize that she's provided some information to you and to the court in the past. She was seeking various different things in terms of jail, diversions, and so forth. I'm sure you had an opportunity to review those, correct?
Yes.
You recognize that none of that is binding upon the court or in any way part of the plea agreement, correct?
Yes, Your Honor.
In other words, I don't mind having Ms. Harris here now or at the time of sentencing to advocate on your behalf, but I want to make sure there's no misunderstanding. That suggestion by Ms. Harris and the recommendation is just that. It's a suggestion and it's a recommendation. It's not a part of the plea agreement. To the extent I followed it, I would follow it. To the extent I don't, I won't. But either way, it would not impact whether or not you would be going forward with sentencing on this file. Do you understand that?
Yes, Your Honor.
The plea agreement in this case calls for you entering what's called a no contest plea to an offense known as attempted false report of a felony. Do you understand that?
Yes, Your Honor.
Attempted false report of a felony is still a felony, and it's a felony that's punishable by a maximum of 2 years in the state prison system and/or a fine of up to $1,000. Do you understand that?
Yes, Your Honor.
And the benefit of the plea agreement is if you plead guilty to that attempt false report of a felony, the prosecutor dismissed the charged offense, which was false report of a felony, a maximum of 4 years, and would also dismiss the second offense notice, habitual offender notice. Do you understand the benefits of the plea agreement?
Yes, Your Honor.
A no contest plea operates much like a guilty plea. For a guilty plea, you would tell me why you're guilty, and I would determine whether or not I believed that you were guilty. For a no contest plea, you would instead have me examine what's called a police report or another document. And I would examine that document and determine based upon what my review of that document was, whether I believed you were guilty of the offense. Do you understand that?
Yes, Your Honor.
If you allow me to read such a police report and make determinations, you cannot later challenge the factual accuracy of those police reports that you're asking me to rely on. Do you understand that?
Yes, Your Honor.
And if I determine that you're guilty after reviewing that police report, you would be just as guilty if you told me you're guilty, and you'd be subject to the same maximum penalties. Do you understand that?
Yes, Your Honor.
Has anyone promised you anything to get you to plead guilty outside of what we talked about in terms of the plea agreement?
No, Your Honor.
I said guilty, but you're pleading no contest. Has anyone threatened you in any way to make you feel like you have to plead no contest?
No.
Are you pleading no contest freely and voluntarily?
Yes, Your Honor.
And is it your own choice to plead no contest?
Yes.
If you plead no contest and I accept your plea, you will no longer have any automatic right to appeal. Do you understand?
Yes, Your Honor.
Instead, you would have to ask the Court of Appeals for leave to appeal, and they could deny that request. Do you understand that?
Yes, Your Honor.
If you plead no contest, you will lose all of your current trial rights. Do you understand that?
Yes, Your Honor.
Those trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving you're guilty on a reasonable doubt. At your trial, you'd have a right to have the witnesses against you appear and to see, hear, and question them. And you would have the right to have the court order any witnesses on your behalf to be ordered to appear at trial. You'd have a right to remain silent at your trial and not have that silence used against you, and you would have the right to testify at your trial if you made that choice. You understand all of those rights?
Yes, Your Honor.
You understand that they're waived if you enter this no contest plea.
Yes.
Miss Kenny, I've had a chance to review a police report. I reviewed that prior, and now I've reviewed the supplement. Counsel, are each of you stipulating to the court's entry of the supplemental police report in the entire packet as Exhibit 1 for the court's purposes for the plea?
Yes.
Yes, sir.
So I'm just marking in Exhibit 1. The court has reviewed that document in its totality in advance of today's plea hearing, and I also was aware of the claims that were made in the first report, and so I'm supplementing those findings today. But the allegation was that on Thursday, 6/29 of 2023, that there was a report, and the report that date first coincides with the information, felony information. And the suggestion was that Miss Kenny had called police, or police were dispatched, and they ultimately came in contact with Miss Kenny, and Miss Kenny claimed on multiple occasions to both a county deputy as well as Officer Grossberg with the Grayling City Police that she was by two different individuals. Her first claim was that she was inside and I want to press charges. She claimed that she was by two different individuals, a Mike and a brother, and she also indicated that she was hit in the face by the men on the cot while there were several different specific questions asked of Miss Kenny by the officers, and both men she claimed had her stated that she was faced by both men and down while being. And when asked, Laura stated that Mike and his brother were down and held up her chest while the incident and events changed several times according to the officers while they were gathering details. And later, there were several different offers made to Miss Kenny. For example, the officers allowed and asked to have services provided to her, for example, taking her to the Grayling Hospital for examination, asked if they would talk to it, if she would be willing to talk to a victim's advocate or any other resources, and Miss Kenny refused all assistance and refused any other services. There was further investigation done. One of the individuals was interviewed and offered to provide a DNA sample, denied any type of contact or in any way, including the alleged. There was also further investigation done. Ms. Kenny took a PBT and was at a 0.24 according to the officers. And further investigation revealed that the officers asked Ms. Kenny to provide a written statement confirming her version of the events. However, multiple times she confirmed that it was from two individuals. Later, on July 17th, so approximately 2.5 weeks after Detective Sergeant John Colado received a phone call from Laura Kenny, and while talking to Kenny over the phone, she began to tell him that she was not by the two men and she wanted to make sure the case was dropped. She further made several statements in regards to not remembering what happened and made statements that she might have dreamed about being by David and Michael. She refused to meet with the deputy, the detective sergeant, and made several statements that she was not. She made statements that she didn't think the men made statements about having flashbacks of a previous from another person, and made statements about wanting to make sure the case was dropped against the two men. Based on that information, the court finds sufficient factual basis to find Ms. Kenny guilty of a false report of a felony, more specifically the felony as charged, and therefore there is a factual basis that I can accept the plea to the lesser offense of attempt. The attorneys believe, based upon the factual information the court has recited, there is a factual basis for an attempted felony.
Yes.
Yes.
And the court obviously takes judicial notice that the false report of the felony was criminal conduct, whether it be in the first or third degree, both would be felonies to the attorney's degree.
Yes.
And Rocky venue has been established that was located at Margaret Lake Road in Grayling, Michigan, which is in Grayling Township. The attorneys further agree.
Yes.
Yes.
Are the attorneys aware of any promises, threats, or inducements that have not been disclosed on the record?
No, Your Honor.
No,
And now do the attorneys believe there's an adequate factual basis?
Yes, Your Honor.
I do.
Ms. Kinney, I find your plea to be freely, knowingly, and voluntarily given. I also find that there is a clear factual basis now with that supplementary police report that you indeed did falsely claim that there was a felony committed against you. And I accept that plea and enter it as an attempt on your record under the plea agreement. The next step in the process is I'm going to have you provide your phone number, and the Department of Corrections is going to reach out to you, set up an interview time, and they're going to interview you, which will result in what's called a pre-sentence investigative report. Then in about a month, you're going to be back here in person, right here in the Crawford County Circuit Courtroom for sentencing. At that sentencing hearing, your attorney, the prosecutor, and myself, and you will all be here in person. So go ahead with your phone number. The court also note that anyone else is open to be here in person as well. This is an open court proceeding, so Ms. Harris, you're welcome to be there as well if you want to be here in person. Ms. Kinney, that will be a required hearing in person. Do you have any questions about any of that?
No, Your Honor.
Counsel, anything further?
No, thank you.
Judge, I would be submitting some attached documents, which I would ask that be attached to the PSI. It would be some counseling records and some records that Ms. Harris has provided my office. We'll attach that. And then I wanted to also just remind Mr. McFarland and Ms. Kinney that when she does prepare her pre-sentence report, the portion where it indicates, explain what happened in this incident in your own words, I would ask that that be left blank because suddenly there's a no contest plea due to lack of memory.
Any response to that, Ms. Coe?
No, I would defer to the probation and parole about how they typically handle those.
Well, I think, and I understand that, but regardless of how probation and parole typically handles it, a no contest plea is different than a guilty plea. And so I'm going to direct that the department not ask any questions about the circumstances of the event. The claim from Ms. Kinney, at least, is that she has no factual recollection of what happened. And so that portion of the PSI should just remain blank, or that it was ordered by the court that the defendant's version of the events is to remain blank. Any questions about that, Mr. McFarland?
No questions, Judge.
Ms. Kinney, we will see you next month for your sentencing. Thank you.
Thank you.
Thank you.
It has been a while, Mr. Tatro. Good morning.
It's pronounced Tatro with a long A.
That's right, it is. I didn't recognize you because I don't think did you have your beard the last time you and I bumped into one another?
My beard was shorter.
See?
I'm waiting for my attorney.
I'm here.
Here, she's right
Okay.
above you.
All right. I didn't see her.
Oh, she's here, believe me. Ms. Coletti appears on behalf of Mr. Tatro. Good morning.
Good morning, Your Honor.
And Marvetta Bowman joins us. Ms. Bowman, good morning.
Good morning. It's Marvita Bauman.
Well,
I'm
I'm
sorry.
two on these things. I'm just going to call plaintiff and defendant. That's probably a lot easier. You pronounce it Bauman?
Bauman.
Okay.
Yes, sir.
I'll make that change. Mr. Tatro long A. Okay, let's get to the important stuff. Not that this isn't important, but let me tell you what I know, because this is Ms. Bauman's motion for custody. The case of Vodvarka versus Grassmeyer was in essence decided. And what that case stood for is the proposition that custody should be something that is rarely brought. They don't want courts interfering with kids' predictability, stability, because these are very destabilizing events. And I don't know if Ms. Coletti knows this. I don't know if Mr. Tatro knows this. I don't know if Ms. Bauman knows this. This is the fourth motion in this case since August of 2023. And quite frankly, that's unacceptable to me. Courts are not here once a year, every year, to weigh in on your lives and the lives of your children. It's just not proper. But I've read your motion, Ms. Bauman. Did you get a copy of that, Ms. Coletti?
I did, Your Honor, and I did file a response.
Let me see. I did get that as well. Thank you. Did you get that, Ms. Bauman?
Yes, Your Honor.
Okay. Then I've read everything. So is there anything you'd like to add, Ms. Bauman, before I hear from Ms. Coletti?
I do want to add that on Wednesday night, I end up having to have a police officer escort me to, well, I wanted him to escort me to Mr. Tatro's property that I'm also banned, that Mr. Tatro has ordered because he felt like I was too aggressive when I was explaining my frustration with him. Instead, the officer went and picked them up and brought them back to me in my safe location, which was just down the road. It was I'm not going to say what it is, but if I can't or if I don't have to. And if you would like that case number, I can read that off to you if you would like.
I don't need it.
Okay, and I also have been using the Family Wizard app, and I feel like I am the only one that is using it to make appointments or to communicate or um, just to co-parent in general. And it's very hard to co-parent with Mr. Tatro because he has a learning conditioning where he can't read really well. So when I'm trying to explain something to him on the phone, he gets very aggressive with me, and it's just hard to communicate with him in general.
Okay, thank you. Ms. Coletti.
First, Sharon, I want to address the police escorting Ms. Bellman to pick up meds. She picks up the children from school on Wednesdays. She had another person pick up from the school. That person who's picking up on her behalf refused to take the meds for the children. We have an order from July of 2024 that says that medicines will be exchanged at the school. That's a Marvita problem, not Mr. Tatro's problem. She then told him to drive to her location. He said, no, you're supposed to pick up the meds at school. You can come to my house, just stay on the street and I'll bring them to you. She refused. Then she sent the police at, I believe, 7:30 at night to go pick up the meds from him. All she had to do was go herself. She is not supposed to be on his property. That's correct. But he told her to come get the meds for the children. So that's what happened. So for her to spin it and say that it's his fault that she had to go send the police to pick up meds is simply not true. The other thing is she changes the children's address at the doctor's so that she gets notices and Mr. Tatro doesn't. She's not supposed to change the children's address, Your Honor, at the doctor's. The primary address is his home, even though they do share joint legal and joint physical custody. I think what I said in my motion is basically this is a frivolous motion. She does not have proper cause or change of circumstance. And I believe, Your Honor, she should be ordered to pay Mr. Tatro's attorney fees for filing this motion. I was aware of the one in 2024. I was not aware of the other 3 that were filed since 2023. And this is just out of hand, and she needs to respect the courts and the court's orders.
May I say something about school?
I was waiting for that, Ms. Bauman. Go ahead.
How can I pick up medications on early release days when I'm at work, and when my person is picking up the kids, she does not feel comfortable with handling the medication because she feels like it is co-parenting's responsibility.
Yeah, that's not even a thing. Who's ever picking up the kids can do the pill exchange. It should always be at school. I don't want you two to go anywhere near each other's property at all, because what law enforcement agency are you two pestering to
It's Pitt County Sheriff's Department. It's the only one that comes to my house. And I had to have her trespass from my property because
I get it. Stop talking, Mr. Tatro. You have an attorney.
Yep.
Your attorney's gonna come unglued at me if I listen to you. She will not let you talk because that's for your own protection. Okay.
Yes, sir.
I don't mind hearing from you. So, one issue that I have with this whole thing is, apparently, Ms. Coletti, the children are having problems riding the bus, and the people involved at the school have suggested that they be dropped off instead of taking the bus. Are you aware of that?
That was in her attachment, that there was an email that appears that both parties agreed that, I think it was October 2023, 2024, to not have the boys ride the bus. But I don't know if Mr. Tatro is able to always drive the children to school.
Well, the problem is, I don't want to set these kids up for problems. And apparently the bus is somewhat of a triggering event. And I don't want a whole bunch of delinquency issues either. As far as this is concerned, are the children being dropped off, or are they still taking the bus?
They are being dropped off every day except for this morning. I had to have them ride the bus. It was what the original issue was is somebody was picking on my son, and with both of my kids being autistic, he takes it out of hand.
Yeah, I know that, and I don't want that to happen.
But majority,
I
but
can't. That's
sorry.
good, Mr. Tatro. I'm really square at it.
May I say something about that situation?
I'll give you the last word.
I have offered for my my roommate, to give rides to, considering my daughter goes to the same school, and he refuses to have my roommate pick them up anytime, whether it's for his parenting time. So, and I always drop off my daughter to the school, or my roommate does, because we live in Cedar and they go to Rockford School. So they have no choice but to get dropped off by my roommate. And she has to drive by his house every single day. And he refuses to let us pick up the kids for him to take them to school.
Thank you. Yeah, I don't know if there's ever going to be peace in this case, Ms. Coletti. It just it's always something. Would you prepare an order, please, Ms. Coletti? I'm going to respectfully deny the motion, Ms. Bauman. There is absolutely no change of proper cause or change of circumstance. The second thing is I'm going to order that the children be dropped off and not bused. I'm going to avoid a problem. If Mr. Tatro can't do it, then someone else can. And also the pill exchange will be at school. That's not even a logical reason that it's into co-parenting. He can,
How about for summer?
He can do that. As far as the summer's concerned, it sounds like to me that maybe the parties should do the pill exchange at a police station, because I don't think they can handle being in the same room with one another. Maybe that's where we got to go, Ms. Coletti, for the pill exchange when the kids are not in school. Okay.
And which one would you like us to use, Rockford or Cedar?
The closest one to where the kids reside, wherever that is.
That would be Rockford.
Then the Rockford Police Department. These are issues that I expect joint legal and physical custodians to figure out on their own and not bring them here. So the sooner you two can, parenting autistic kids has got to be one heck of a nightmare. I mean, that's got to be, they're wonderful kids, but that's got to be so challenging. And you make it so hard on one another by this constant infighting. Maybe if that taps down and the kids see their parents at least civil to one another, maybe that will help in their treatment for this. So any questions on what I need the order to say, Ms. Coletti?
No, Your Honor, I think I have down what will occur. I'm just curious how, if the roommate won't pick up the pills from school, how the pills get dropped off at school with the children when they're in Marvita's care.
I don't know.
I dropped them off after school. I dropped them off after school.
Done.
One other question, Your Honor. Are you reserving attorney fees, or are you granting?
Yes. No, I'm reserving them.
So if Ms. Bauman, just so she knows, if she does file another frivolous motion, will you be inclined to award them?
I'm heading there.
Okay.
Come on, let's get along. This is getting crazy. We're adjourned. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
We will go on the record in the matters 24 CF 104, 24 TR 469, 470, 471, and 472. State of Wisconsin, County of Burnett versus Gavin Jones. The state appears through Assistant District Attorney Holly Rockow in person. We have Mr. Jones appearing in person with counsel Gregory Amon. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Amon, can you please recite it for the record?
Yes, Your Honor. Mr. Jones will plead guilty to amended count 1, amended to resisting or obstructing with a motor vehicle in violation of Wisconsin statute 346.04 parens 2T, which is a class A misdemeanor. Joint recommendation is that sentence will be withheld for year probation. Conditions will include AODA mental health evaluation if requested by the agent, DNA surcharge sample, and the other charges and the traffic matters will be dismissed and read in.
Ms. Rockow, with this agreement that's been reached, why is it in the public interest, as it was charged as 2 serious felonies and a low-end misdemeanor, to have it be resolved to this resisting, obstructing with a motor vehicle, class A?
Your Honor, I reviewed the facts as well as Mr. Jones' criminal history in both Minnesota and Wisconsin. He has no criminal convictions on his record whatsoever. This incident began in Minnesota. He was traveling at a very high rate of speed in Minnesota. Continued into Wisconsin, where he was ultimately stopped. I think the state would have a pretty difficult time at trial proving the recklessly endangering safety based on the facts. He was simply just speeding and disobeying law enforcement lights and sirens to pull over. I talked with Mr. Amon about a resolution that would avoid a felony for Mr. Jones, as this is his very first criminal conviction. And Mr. Jones was wanting to take responsibility for his actions in pleading to a class A misdemeanor. I think that the background for what was going on with Mr. Jones will provide the best context, and I'll let Mr. Amon talk about that. But it's my understanding that there was a family situation happening, and Mr. Jones was aware that if he was pulled over, he wouldn't get to his daughter in time. And that would have some pretty serious implications for his life and his daughter's life going forward. He told the officer right away that he panicked. He explained, he was honest. He explained what was going on. He did mention trying to get to the daughter. I think his head was just not in the right space, and he made a very, very, very bad choice. But ultimately, he was cooperative, and ultimately, he's here taking responsibility. I think that having this, albeit a misdemeanor, a class A misdemeanor conviction on his record is going to serve as a reminder to Mr. Jones about what happened here. And should he have criminogenic needs that can be addressed, those can be addressed on probation. I think that'll keep the community safe.
All right, thank you.
I can add a couple things to that, Judge, if you'd like me to, or I can wait until
You can wait until argument.
Okay.
Has there been any discussion about expunction, and or has there been any charges filed in Minnesota?
Both. Those are the 2 things I was going to mention.
Alrighty then.
And I was also going to mention, since I'm at it, that you had 4 days custody credit in Wisconsin and also had some custody credit in Minnesota. They only gave him 1 day credit, but he tells me he was in jail for more than a week. And I think that's probably accurate from what I can figure out. 2 things. Yes, I was going to request and will request expungement for successful completion. He still has to get his probation completed successfully. But what happened in Minnesota was he ended up pleading to a felony charge there. He's on probation. How long are you on probation for there? Minnesota?
3 years.
3 years. So he will have that measure of supervision, but it's one of those stay of adjudication so that if he successfully completes that, it'll end up being a misdemeanor. So that coupled with this is probably a fair result for the overall situation. And I will explain again in more detail what happened that led him to start this course of conduct that evening.
All right, thank you. Can I have the plea questionnaire waiver of rights form, please? Thank you. All right, I have the plea questionnaire waiver of rights form. Mr. Jones, did you go over this document with your attorney?
Yes, Your Honor.
Did he go over it thoroughly with you?
Yes, Your Honor.
Did he essentially read it to you word for word?
Yes, Your Honor.
And so you understand everything on that document?
Yes, I do.
And if you did not understand something, did you ask him to explain it to you?
Yes.
And he did so.
Yes.
And so you're telling the court you fully understand everything on this document.
Yes.
You are pleading guilty to one count of operating a motor vehicle and disobeying an officer's commands under Wisconsin statute 346.04 paren 2T. You're 23 years old. You have 12 years of schooling. You can read, write, and you understand the English language. That's all correct.
Yes, Your Honor.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes, Your Honor.
You are receiving treatment for a mental illness or disorder. Is that something that interferes with your ability to comprehend or understand what's going on?
No.
So you're in a position here today where you fully comprehend and fully understand everything.
Yes, Your Honor.
You are not taking any medications and you've not had any alcohol or other drugs, correct?
No, I have not.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on this document. Next to the rights is a box, and each of those boxes is checked. That tells me that your attorney went over those rights with you and you understand them. Is that correct?
Yes, Your Honor.
So you fully understand those rights.
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove on or around May 4th, 2024, that you were an operator of a vehicle and you received a visual or audible signal telling you to stop your vehicle from a traffic officer or a federal law enforcement officer or a marked or unmarked police vehicle that you knew or you should have known was an officer and being operated by an officer, but you knowingly resisted that officer or obstructed that officer by failing to stop your vehicle promptly and in a safe and reasonable manner. Do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you do face a fine of up to $10,000 or imprisonment of up to 9 months of incarceration or both?
Yes.
And do you understand that the recommendation to the court is to place you on 1 year of probation with what's called a withheld sentence? That means to have the whole entire 9 months held over your head instead of telling you today what the sentence could be if you're revoked. Do you understand that's simply a recommendation to the court?
Yes.
Said differently, do you understand that I could sentence you today all the way up to that maximum possible sentence, which could be that maximum possible jail time if I thought it was warranted? Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney? And that's that original document that basically says what happened that day and why you were charged with those crimes.
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did fail by resisting or obstructing, fail to pull your vehicle over after being prompted by a law enforcement officer through either audible or visual signals?
Yes.
And you knew or reasonably should have known that it was an officer.
Yes.
Mr. Almond, may the court use the probable cause section of the criminal complaint to find a factual basis.
Yes.
Has anyone made any threats or any promises to you, Mr. Jones, for you to plead guilty to this charge?
No.
You're doing so freely and intelligently. That means you're telling me you fully understand what you're doing here today
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
Formal motion to amend count 1, Ms. Rockow.
So made.
Court will grant that motion. As to the amended count of obstructing an officer by failing to turn your vehicle over or by use of vehicle, a class A misdemeanor, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Counts 2 and 3 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Ms. Rockow.
Your Honor, I'd ask the court to adopt our joint recommendation and withhold sentence, place Mr. Jones on a period of 1 year of probation. For the reasons that I've already stated, I believe this to be in the public interest. Thank you.
All right, Mr. Almond.
Well, this is well, I'm going to start currently. Mr. Jones was pulled over within the last couple of days, and actually pulled over before the cop even put his lights on. Because he wasn't going to let this happen again. Ultimately, after they maneuvered around each other a little bit, there wasn't any issue, any problem, and Mr. Jones has already reported that to his probation agent in Minnesota. So his behavior is quite different than it was in this particular evening. But what he explains to me is that he stopped for gas in Hinckley, and he was on his way home where his daughter was, and he and the daughter's mother were having custody issues at the time. And had he not gotten there on time, the mother would have ended up with the child, and there would have been issues wrangling back and forth about that. And have I got that so far?
Yes.
And when he didn't have a license at the time. So when he saw the officer, he started to pull over, and then all this business went through his head about his daughter. And he basically tried to get away. That's how that's how the, as warped or wrong as it was, that's how the thought process went into this. And yes, he said he panicked. I think he was straight up with the officers and the whole thing. And he did what he needed to do here. And I think with no criminal history at age 23, it's really I think it's an aberration of behavior that was dictated largely the circumstances. He also does suffer from depression. And I don't know if that played any role in the thought process or lack of thought process at the time, but he's now received medication for that and is just starting to take that. So hopefully that will never be a problem for him again, at least not that he can't address.
Thank you. What happened with the child? Did you have to go to family court, and did this cause an issue?
The issue wasn't with my wife at the time, it was with her roommate. I had reason to believe that he was my daughter, so I didn't want her going back to her mom's house, which she ended up going back to her mom's house. And then I convinced her to move to her mother's house instead to get her away from him. And we are actually back together now. We live in Grand Rapids.
You're back together with your wife? Or?
Yes.
Yes. Well, that's good to hear. So you've been able to work through those problems and those issues?
Yes.
And so you said Grand Rapids, and that's an address we have. Are you still in apartment 33 then?
Yes.
Excellent. Okay. Well, I'm really glad to hear that. So I'm glad to hear that you were able to work out the issues that you had with your significant other, and that you're working towards having a stable relationship with her and with your child. So that's good to hear. Is there anything else that you want to let me know? You want to fill me in on? You don't have to make a statement or tell me anything, but this is the only time that you have to let me know anything.
Nothing I can think of.
And Mr. Almond, so I can understand that the crimes that he was charged with here in Burnett County, this is the same day exactly as the crime, the felony he pled to in Minnesota, correct?
It was a continuation of the same events, I think.
And that's what I believe to have occurred. So, Mr. Jones, when a court sentences an individual, there are various factors and various things that come into play. First and foremost, I have to look at the seriousness of the offense. Then I have to look at the individual in front of me and various factors among them, your age, your criminal history, your mental capacity, your health, those types of things. I also have to look at the need to protect the public interest. I also have to look at if you have any rehabilitative needs and if they're being addressed right now, if you have the ability to address them in the community, or if this is something that I need to look at deterrence, deterring you from doing this again, deterring others from committing the same or similar crime. There's a lot of things that come into play when a judge sentences an individual. And I'm sure you're aware of that. Even though you don't have much of a criminal history, this is your criminal history. This day is your criminal history. I'm sure it was similar in Minnesota when you were in front of the judge. So when I'm looking at this, I'm seeing a very young man, a 23-year-old who was under a lot of stress and trauma at the time. You had a lot of fear, a lot of anxiety, a lot of things going on that day on May 4th, 2024, when you believed that something was going to occur or happen with your daughter. Now, did you violate the law? You sure did. Did you put others at risk? You sure did. And so that's why I do see a little bit why the reckless endangering was initially charged, because it could have. You were driving at such a high rate of speed, you could have endangered somebody's life. If something would have occurred, if something would have jumped out at you and you swerved your car, you could have hurt or killed somebody during that process. So it is a serious crime. But you don't have a criminal history. You're young. You are looking at doing something with your life. Are you working? Are you going to school?
I'm working as an HHA at an assisted living, and I was looking at going to college to become an RN.
Excellent. That's very excellent. I'm very glad to hear that. We need more good RNs, registered nurses. We need people who, but you have to be very attentive, because the nurses really, for real, they're the backbone of the whole medical field. They really are. I want you to be able to do that. So when are you looking at applying or starting school, starting your associates to build towards getting your RN?
I was hoping to start college the next semester that's available in the fall, I think. I live a 5-minute walk from the college.
Oh, that's even better. That's good to hear. This day of May 4th, 2024, this day, you are a risk to the community. I think and I believe that you have made some changes in your life, and you now have a better understanding of what occurred that day and the risks of what could happen if you were to do this again. And the fact that if you were to do this again, the fact that you were charged with these charges, they just don't go away. They stay on CCAP forever. They stay in law enforcement's databases forever, and they can see and they can look and say, okay, he has done this before. Maybe this time is the time that we need to be cracking down hard on him. But I don't think this is the time to crack down hard on you. Because I really think that you've already been cracked down hard on in Minnesota by pleading to a felony and being on probation for 3 years there. You're from Minnesota. You're on probation for 3 years. You check in with your agent. You meet with your probation agent. You're doing the programs that your agent is telling you to do. You're doing all that you should be doing in Minnesota. I don't see what double probation is going to do. I don't see what it's going to help by having Wisconsin also supervise you, also spend the resources to provide you with services or to make sure that you're following the line and not committing crimes. I'm going to guess you were just kind of driving through Burnett County. This wasn't even some stop of yours, correct?
Correct.
And so this was just a happenstance. So you're not a risk to Burnett County. And so based upon that, although if it were somebody else with different facts and different things to look at, I would do a different decision. But my job is to look at the facts in front of me, the person in front of me, the things that happened and occurred, as well as to look at what happened in Minnesota and what's happening there now and will for the next 3 years. So what I'm going to do is, I didn't say it before, but all of the TR matters are dismissed and read in as well. I'm going to assess $750 for a fine, 5 days of jail, 4 days jail credit. That means it's a time served. I'm not going to put you on probation. I'm not going to double probation you. You're already on probation in Minnesota. Do what your probation agent says, because if you do what your probation agent says, you're going to have your felony go away, and that's going to help you be an RN. If you don't, it's going to be difficult for you. All right. So even though this was different jurisdictions, it really resulted out of the same crime. And yes, you can be punished twice, and you kind of are. You've already pled guilty to a felony. That is on your record, at least for 3 years. And I'm taking $750 that you could probably use. So $750 cash. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You do owe for Mr. Amon's services, and I don't know what that is. No, he's PD appointed. Oh, he's PD appointed. Sorry. Okay, so you don't owe for Mr. Amon. But I need your DNA. When you're done here, you have to go right over to the Sheriff's Department, provide your DNA, and then you should be free to go. You have the right to request it be expunged through a written letter to the Department of Justice, not here, to the Department of Justice, if you wish to do that. I think that covers everything. Ms. Rockow.
Nothing more from the state, Judge.
Mr. Amon.
I think you noted the 750 must be the amount based upon the amount he has posted, so that'll come from his
It is.
bond.
He owes no more.
Right.
All right, then
Good
we
to
are
go.
adjourned. Thank you.
Thank you.
All right, the court will call the case of the state of Michigan versus Ronika Favors, case number 24S00248.
Tiffany Woods for the people. Allison Muller, Assistant Public Defender, here on behalf of Ms. Favors. Ms. Favors, could you unmute and state your name, please?
Ronika Favors.
Thank you. Good morning, Ms. Favors.
Good morning.
Good afternoon already. All right, we're here for sentencing. Have you had a chance to review the report with your client?
I have, Your Honor. We went over the sentencing report. No corrections, modifications, or deletions. We do ask the court to follow it.
Thank you, Ms. White.
Yes, Judge. I would also ask the court to follow the recommendations, but I also wanted to bring up the fact that defendant has missed 4 tests, and then she tested positive for TB on November 26th after you told her at the last hearing that she has to stop testing positive for TB or she was going to be in violation. So I didn't know if you wanted to discuss that with her at this time.
Ms. Favors, anything you want to say before I impose sentence on you, ma'am?
Well, yes, actually, I missed the 4 times because I was confused about when we were here last, where I was reporting to, when I got the information for probation, I asked you if it was the same place and you told me no. So when I found out about the alcohol assessment and what I had to do with the third party I was referred to, I was under the impression that I was going to start testing there, but I never saw her in person.
No one ever told you to test anywhere else, ma'am. We told you to get an alcohol assessment done.
Okay.
All right, the court at this time will follow the recommendation of the probation department. It is the sentence of this court that you serve 93 days in a Washington County jail. Credit for 0 days served. The 93 days are suspended. Ma'am, you missed another test. Test positive for TB. I'm gonna issue a bench warrant. You will be arrested and sent to jail. Do you understand?
Yes, I understand, but I needed it for a medical condition as well. So I don't know if that matters or not.
It doesn't when you're using THC when you couldn't commit an offense. You're no longer eligible to continue to use. You're driving while you have THC and a blood alcohol content of 0.197.
Okay, well, I was told something different at community corrections.
Your Honor,
Yes, it sounds like she wants to do what community corrections said and not what this judge said. So it sounds like we have a problem.
Your Honor, Ms. Favors will follow the court's order. Her and I just discussed yesterday that I said that it's no guarantee, but she could try to get a doctor's letter and consider that for your consideration. But I told her it's not approved, and I explained that it was a violation of the act, and she understands that. She will comply. She does plan to get a doctor's letter, but again, I told her that was for the court's consideration and not a guarantee that it would be approved. I just wanted to ask if she could get when she goes to test, can she get a confirmation with the result? I don't know that it will immediately be a negative, but she should be able to show that her levels are decreasing.
I already told her the last time that she was here on October 24th not to use.
I understand.
And she uses every excuse that she wants to, not showing up for 4 times the test, and then shows up with THC in her system. And now she's arguing with me today.
Well, I didn't show up with THC in my
Ms. Favors,
system.
She goes, ma'am.
Ms. Favors, I think we should leave it for now. We want the court to follow the recommendation. You and I can talk after court further, okay?
Okay.
I don't know that I'm going to follow the recommendation because she doesn't understand. So maybe a taste of jail will help her to understand.
Well, I just wanted a chance to talk. I'm not trying to argue with you.
Yeah,
You had a chance to talk, and you do keep arguing with me. Anything else you want to say?
Well, I did have something to say, but you're taking it offensive.
No, I'm
just
not. I'm taking it as it is, which is you're not going to follow the court's orders.
Well, I am going to follow the court's orders. I just wanted to be heard out. I didn't show
Your Honor,
back.
when I talked with Ms. Favors last night, the one thing she did say to me that she realizes this could have ended much differently. Especially, I think maybe the THC component, her and I need to talk further, but she definitely understands the danger that the alcohol played while driving. But her and I will talk further why the THC is important in this case as well. But she totally, at least to me, was understanding that this was a totally dangerous situation, that she was at fault. She is apologetic for her actions, and that's what she indicated to me last night. I know
That's what you're saying. She is not saying anything like that.
Well, when I tried to speak, he said I was arguing with you. I don't want to argue.
You have anything else to say?
Yes. When I missed the 4 times to test, when I showed back up, I did not test positive for THC. And I still can show you that I have not done that. Yes, I got my certification and I can get my letter on why I need to.
I don't care if you get a letter. You're not going to be using it.
Okay, that's fine. I was just letting you know that I can still show you that.
She is indicating that she did not test positive for THC, although it says here we did. It sounds like we need to have a hearing on this. And
Your Honor.
No, we're done talking about this, Ms. Mueller. And it sounds like it needs to happen in person next week, December 12th, 2024 at 11 a.m. in person. If it's found that she tested positive, then she's going to jail. See you there. Okay, so I don't really have much to say about these videos because they were all pretty much
they told it like it is. So I don't have anything to add about any one of them. They were all different, but I really appreciate you guys for sticking with me on it, and thank you so much for watching. I'll see you next time.